continues to apply to some groups of people in Zambia. So the two systems of law apply to different groups of law. That is the Intestinal Succession Act and the English Act in force, the English law in force in 1911. Our focus in this presentation.
Recording in progress.
Our focus in this presentation, could you please move down? Our focus on this in this presentation is the Intestate Succession Act, for the simple reason that this is the act that applies to most people in Zambia. That is Zambians of African, indigenous Africans, and belonging to the 73 or there are about 73 tribes of Zambia. Now, I did explain last time when we met that the act applies to estates of people who would otherwise have been governed by customary law if this act did not come into existence. And the majority of these are Zambians who belong to the 73 tribes of our country. Please move on. Now, when we are discussing the scheme of distribution of estates, I want to emphasize the importance of precedent. Now, precedent is simply means that the courts follow the previous decisions of superior courts, like the High Court, the Court of Appeal, the Supreme Court, and the Constitutional Court. So the laws, the decisions that are made by these courts make part of the Zambian law on any subject. So please pay attention to court cases when you are considering to administer an estate, to distribute an estate. Consider the importance of court cases that have been decided on any particular issue, so that you do not lose out on the benefits of a court decision that was decided on the particular matter in question. So let's move on to the next slide, which is the aims of the Act. No, please next. Next slide. Yes, that one. The Intestate Succession Act changed the customary law of succession, which was generally organized on the basis of whether the deceased person belonged to a patrilineal or matrilineal tribe. But generally, in both of these systems of succession, the spouses did not inherit from each other. And the widows obviously suffered most from these laws, as they were deprived of the deceased husband's property to support themselves and their children, who were often left in their custody. Why women? Widows, because in generally speaking, women in Zambia are the most disadvantaged in economic terms. They are among the vulnerable groups that suffer from economic dependence on other members of the family. So these customary laws, which excluded them and the children from inheritance, often left them in a very difficult situation. So the main objective of the Act was to change these aspects of customary law in order to include primarily the spouses and children of the deceased person in the distribution of the estate. Of the estate in terms of the Intestate Succession Act. I think most of us are already familiar. This is a subject which fortunately is increasingly becoming quite familiar to most of the people in Zambia. The Act has been in force since 1989. And so people have gotten to administering the estates, or at least most of the estates, in terms of this act. So we'll look at the percentages of distribution of the estate. The first percentage under the act is the 20% of the estate to the surviving spouse. Where more than one widow of a polygamous marriage survives, the 20% is shared by all of them according to the duration of their respective marriages. And the courts, if it came to the courts or administrators, take into account certain factors such as the widow's distribution to the deceased contribution to the deceased's property, or the length of the marriage. So that's the one aspect where the marriage is polygamous. The court or the administrator has to take into account some of these factors, but particularly the widow's contribution to the deceased person's estate. And this is trying to catch a situation where a man gets married to another woman today, and tomorrow they die. In law, as long as that marriage is valid, that woman is entitled to inherit. And without this kind of restriction, looking at some of the factors concerning the marriage of the deceased, some widows will have more advantage of others. Particularly the more recent widows will have more advantages over the distribution of the estate than the older widows. I think I'll stop there. Is that clear? That particular provision, particularly where it concerns the distribution of polygamous marriage estates. Is there any question of clarity? Hello, can you hear me?
Yes, we can.
Oh, thank you. Thank you so much. Somehow something happened on the screen again. So that is the first distribution. If there is no question, then we go to the second, which is the 50%. No, before I go there, I think I should mention that these polygamous marriages, the estates that involve polygamous marriages, can get very complicated, and some of them have ended up in court. For example, in one case decided by the High Court in 2019, the deceased left 2 widows and 8 children, all above 20. The children are above 21 years of age. The administrator gave the estate, a part of the estate, to the widow. So the administrator gave part of the estate to the second wife, and the first wife, obviously. And then after that, the distribution of the estate, the administrator died. And then the children of the first marriage claimed a share as well of the house of the second wife, which was given to that family. And of course, she claimed that the children claimed that they had a right to share in the house that was given to the second wife and her children. The court decided that land on which the house for the second wife was part of the matrimonial homestead of that second wife and her family, and that she was therefore entitled to that property to the exclusion of the children of the first marriage. So the principle that seems to come out of this case seems to be that where there is sufficient immovable property, each of the wives and her family and their families will inherit a home to live in. But the complication here is really usually in practice that one family tries to take advantage over the other and claim an inheritance from the estate that belongs to the other. And I suppose this is the nature of polygamous marriages. The fightings, the jealousies between the wives of the different wives of the estate, also of the deceased, also contribute to the complications in the administration. Distributed in such proportions as are commensurate with the child's age or educational needs. So here, the distribution takes into account the special needs of the children. The younger children who may still be in school may take of that 50% a larger share than the older children, for example, who are already working. But remember here that the definition of children under the Act includes extramarital children as well. That is children born out of the marriage. And again, in practice, this causes quite a bit of a struggle between the different families in polygamous marriages. Then we come to the 20% of the estate. The Act defines that goes to the parents. 20% of the estate to the parents of the deceased. And the Act defines a parent to include a guardian who has been responsible for the welfare and education of the deceased. Now, the courts have decided on what a parent who should inherit under this 20% distribution is. In one case, which was decided by the High Court in 2016, the deceased was survived by a widow, children, biological parent, and a stepmother. The administrator of the estate gave the same amount of the estate to both the biological mother and the stepmother. The biological mother had been keeping the deceased in their home since he was 5 years of age. The biological mother disputed the distribution of the estate to the stepmother. She argued that she could not claim the estate because the estate envisaged distribution only to the biological parent. The court decided that the deceased had lived with his stepmother from the age of 5 until he was able to live on his own. And she, during that time, contributed her entire National Provident Fund earnings towards the upkeep and education of the deceased. The court further decided that the stepmother had full parental responsibility, and she was therefore a parent within the meaning of this act. And it accordingly decided that the administrator was right in giving an equal share of the parent's estate to both the biological and stepmother. So they shared the 20% of the estate in equal shares. I see a question. Okay, there's. Can I take that? What is the question here is what of normal marriages? Now, what is a normal marriage? Sorry, Sister Habenzo. What do you mean by a normal marriage. I'll wait to get that the feedback, then I can answer the question so that we don't lose too much time in our presentation. Sister Habenzu, I'm addressing your question soon. If you can just clarify what you mean by a normal marriage. There are two types of marriages in Zambia. There is a customary marriage, which may be monogamous or polygamous. And both the monogamous and polygamous marriages are recognized by the Act. So the spouses and families from both those marriages inherit under the Act in terms of inheriting the 20% for the widows. Then you have a marriage which is under the Marriage Act. And this act does not admit of polygamous marriages. In other words, you can't marry a man cannot marry more than one wife in a marriage that was entered into in accordance with the Marriages Act. I don't know if that's what you mean by normal marriage, but in that case, the issue of polygamous marriages does not arise. So the spouse is just the widow, the one widow of the deceased who is entitled to 20% of the estate. And if a man in a customary marriage is married to only one wife, then that is that wife alone who is entitled to the 20%. The problem only arises, like in this case, in one of the cases where the deceased had more than one family. That is the case we looked at earlier. Okay. Hope that answers the question. If not, please bring it up in the discussion. So let's go then to the last distribution, which is the dependents. 10% of the estate goes to the dependents of the deceased person. Now, this is a very problematic provision in the sense that the Act does not really define or differentiate between priority dependents and other dependents. Priority dependents are defined by the Act as the spouse, the children, and the parents. So it's not clear whether that category of people also inherit this 10%. Now, in the one of the cases, well, let me put it this way. There are 3 criteria that are indicated here in the definition of a dependent. So I have seen this question. May I just choose it? The Act defines a dependent as a person who was maintained by that deceased person immediately prior to his death, and who was maintained by the deceased person immediately prior to his death, and who was a person living with a deceased person, or a minor whose education was being provided for by that deceased person, and who is incapable, either wholly or in part, of maintaining himself. So these are the 3 criteria, if you like, that define who a dependent person is in terms of the Act. But what is not clear, as I said, is whether this definition also includes the priority dependents who are defined in the Act as husband, wife, or child. In my view, and this is just my considered view, I would suggest that this priority dependents should not be included in the 10% because they are already provided for separately in the rules that we have already discussed. That is the share for the spouse and the widow, and then the parents who take the other 20%. Okay, so that's my view anyway. I haven't seen a court that has decided on this, a case that has decided on this matter as yet. But there is even a more controversial aspect of this provision, and this is whether this section includes mistresses of the deceased person as well. That's why in my topics for today, I included inheritance rights of cohabitants. That is, people who are living together, whether as mistress and the husband of another woman, or just living together without being married. In interpreting this section, the courts have decided, at least in 2 cases, that the distribution includes this category of people, that it includes the unmarried persons, but also includes the mistress of the deceased person. In the first case, the Supreme Court decided that any person who meets these 3 criteria, having been maintained by the deceased person prior to his death, having lived with the person, and C, being a minor whose education was being provided for by the deceased, is entitled to inherit the 10%. And on the facts of that case, the court held that the woman who had cohabited with the deceased in the absence of a marriage and who was being maintained by him was a dependent. Obviously, you can see that the court has overlooked the fact that there is a slight connection between a minor whose education was being provided for by the deceased and incapable of supporting himself or herself. So the court ignored the fact that to qualify here, the person must be a dependent as a minor. They simply went ahead and said, if there's another person in the provided mistress by the deceased and incapable of supporting himself. Oh, this is playing back to me. What is happening, Mr. Rogers? What is happening?
It's okay, you can continue.
Okay, so anyhow, that's it. That's the Supreme Court, and the Supreme Court is the highest court in the land on matters other than constitutional matters. And then there was also, in fact, in that case, the lawyer for the applicant contended that the act was intended, this section was intended to cater for close relatives and not every person, including mistresses. The court decided that if that were the case, then the act should have said so clearly. So that's the situation at the moment. And in 2001, the High Court decided another case where it said that a woman who failed to establish the existence of a valid customary marriage to the deceased person, but who deceased, and that she was entitled to 10%. So the court here made it clear that the section is not just looking at minors or young children as dependents, but adult dependents as well, who are dependent on the deceased immediately before his death. Okay, please move on. I've seen some comments here. May I ask that we perhaps discuss this at the end? Okay. So that is the reason why I included this this category of beneficiaries, the cohabitants, just to bring to your attention that in fact the courts do not Although the Act does not specifically say that a mistress or an adult person should be entitled, the courts have decided that this category of people should be entitled. And as I said, these decisions are important because they make part of the Zambian law on the intestate succession or relating to the Intestate Succession Act. Okay, I think I should stop here and go back to the, because we are now entering another area of intestate succession. Let me go back to the notes here that have been posted. Sister Benzumaka, have you decided what a normal marriage is, or are you clear from that explanation?
Sister Habenzumaka is on Facebook. When she clarifies, then we'll post the question here.
Okay, thank you. So the next question is, in the case you have just cited of the stepmother, did the court ask for proof of adoption of the said child by the stepmother? No, the court did not, or just the fact that this child was kept and raised by the said stepmother. In fact, the latter is the correct. There was no proof, or neither did the court require any facts to show that the child had been adopted, because the section is very clear on adopted children. They are part of the deceased children as any other ordinary children. But in this case, we are talking about people who are being maintained by the deceased person. And the only requirement is the factual situation, showing that, in fact, this person had been looked after by the couple, the stepmother, for during the period of her marriage with the father, from the age of 5 years. So I don't know if there is any follow-up question on that, but there was no need under the law to actually prove that there was an adoption. Because if you remember, those 3 criteria say nothing about the person being adopted. Is that clear, Sister Kayunga? Okay, I assume you can ask any further questions if you like to, a little later. Okay. Then we come to, so this is scheme of rules that we saw, the 20% spouses, the 50% children, the 20% parents, the 10% dependents, is what we may call, for the purposes of ease of reference, the primary scheme for sharing the estate of the deceased. But there are exceptions to this primary scheme of sharing the estate. And these exceptions relate to the sharing of personal chattels and the house of the deceased. So despite these provisions, there are other rules which are exceptions to the application of the distribution of the estate. So we'll consider a number of scenarios that arise or relate to these exceptions. Please go to the next slide. The first scenario is that the surviving spouse or children, or both of them, are entitled to the personal chattels of the deceased person. And we saw in the previous presentation what constitutes personal chattels. That is clothing, jewelry, articles of adornment, simple agricultural equipment, the motor vehicles, furniture, all these chattels are shared by the spouse and children, where they are children, or one of them, the category, if the other is not, did not survive the deceased person. And they are entitled to this property absolutely in equal shares. And I think this is very important to take note of, because most of the estates in Zambia, which do not have immovable property or land that the deceased left, they actually consist of this kind of property, the chattels. So this kind of property, despite the fact that the primary rules provide that 50% surviving spouse, where of course the deceased left money and securities of different kinds, those do not are not affected by that. So they are shared according to the primary rules of the primary scheme of distribution. That is 50% are children, 20% the spouses. The second one is that in the case of polygamous marriages, each surviving spouse or her children by the deceased or all of them are entitled absolutely to personal chattels in their homestead. And obviously the homestead is that part of the house that belonged during the life of the deceased person to the deceased, to the wife and children of the deceased. So any property that was used during the course of the marriage of a polygamous relationship, the parties, the spouses and the children of each homestead are entitled to the property that was that belonged to that homestead. But all widows and all their children are entitled to the deceased's common property, which is defined as the personal chattels used in common by him, that is the deceased, and all his wives and children of every household. So that is the property that is shared by all of, in this polygamous relationship, by all the children and the spouses of the deceased person. Okay, can you please move on to the next one? This is another important area, even I italicized it. The important exception relating to the inheritance of their house. So in addition to their share of the estate in according to the primary scheme, that is 50%, 20%, 10%, 20%, that is the primary scheme. In addition to that scheme, and also in addition to the rules that we have just seen that relate to the sharing of the personal chattels by the surviving spouse and children, the widows, sorry, let me say the spouses are entitled to a share. Spouses and children are entitled to a share of the house of the deceased. Where they are more than one house, the law gives them the right to choose the house that they would like to have. In the case of the deceased being survived by more than one spouse, again, here we are talking about the polygamous marriage. In that case, the spouses or children of more than of this relationship are entitled to this property, but they are entitled to hold the title jointly as what the law calls tenants in common. The interest of the wife in this case is a life interest that only exists in that property as long as the wife or the widow is not remarried. The moment they remarry, they drop out of the sharing of the house and leave it to the children of the deceased. Can we move on? Roger? We want to flag something here. This, I've put here a red flag here. You know, holding immovable property, the holding of immovable property by a group of beneficiaries, such as tenants in common in polygamous marriages, may become very difficult if the joint tenants in that group of owners of the property have disagreements with each other. Now, there was one case in which the High Court decided that in such cases, the tenants in common may be redefined, which would mean, for example, that the property concerned is resurveyed and split and divided among the joint tenants or the beneficiaries in equal shares. In fact, this is really the easiest way to go in the case of polygamous marriages. The next exception is that the surviving spouse and children, where neither of these survive the deceased, the surviving spouse and children, or where neither of these survive the deceased, his or her parents are the sole beneficiaries in the case of a small estate. And the small estate is defined as an estate which is valued at 30,000 kwacha. I'm not sure whether this has changed, since 30,000 kwacha now really means very little, and these must be extremely small estates. I don't know if Sister Kapimba is on the platform. Since she's in practice, she may have come across a change in the value of the estate, which is left to the parents of the deceased, where there are no spouses or children. Perhaps she could assist a little later if she is on the platform. The next rule is that any person entitled to a share in the estate may transfer his or her share to the priority dependents. So there's no law that prevents a person, a generous person, from transferring their 50% of the primary distribution, their 20% or 20% or 10% to a member of this group called the priority dependents, that is the spouse, child, or parent. And this obviously can be very useful in families where some members who are entitled to inherit are quite well off compared to some of what the spouse or child or parent would get under the estate. So you are free as a beneficiary to transfer your estate to another person who is a spouse, a child, or a parent. And the last rule, the last exception rule, is a priority dependent whose portion of the estate under the primary scheme is unreasonably small, having regard to his or her degree of dependence on the deceased, shall have the right to apply to a court for adjustment to be made to the portions of the property of the inherited property. So if a child, for example, is in greater need of support because of their dependence on the deceased, then the spouse, the surviving spouse, or the surviving parent, the court may adjust the shares of these people, including the dependents, of course, in order to cater for the needs of this child who needs more support than the other. And in this application, the court will look at the same law that applies to wills and inheritance of estates that my co-panelist presented in the last presentation, where a person who has not received sufficient inheritance under the will may apply to the court for a readjustment or for reasonable maintenance from the deceased estate. Okay, then next we want to move on to the distribution of the distribution scheme where the deceased is. Maybe before we move there, are there any questions? Because this is another completely different area of inheritance. Okay, there is a question. Let me just see. There's a question from Sister Mitch Mwaka on Facebook. What happens where the parents of the deceased are late and all the children are above 21 years of age? How is the sharing done? Now remember, okay, this is actually the next section that we are moving to. But remember that the sharing of the estate does not depend on the age of beneficiaries. Children of the deceased person who are above the age of 21 years, who are adults, if you like, are entitled to inherit as well, except that is we have already seen where the share of 50% is to be distributed to adult children of the deceased and the minor children of the deceased. The law allows for adjustment of those shares of the children. Instead of them sharing equally, the distribution, the administrator may share a larger portion of the estate to underage children. But you will see in the next section, was it sister or brother? Sister Mitch, Sister Mwaka, or Brother Mwaka, sorry, pardon me. You will see what happens when the deceased is not survived by some of the groups that would otherwise inherit under the primary scheme. I hope your question will be answered there. And if not, you can ask again. So can we move to the next section, please? That is distribution scheme. Distribution scheme.
Yes, I have posted a question asking, suppose the deceased did not have dependents, where does the 10% go? Perhaps I missed that in your presentation.
No, I'm coming to that.
Okay.
That's where we see what happens when, remember, the dependents, the spouses, the children are primary. Now that's the wrong slide. Sorry, Roger. Can you go to the next? Okay. I don't know, my slides were cut. Maybe you can stop sharing at that point. I think I didn't get that one. So sister, just stop sharing it. Thank you. So Sister Mwaka, what happens is the next stage that we are looking at. where the primary beneficiaries, that is the spouse, the children, the parents, the dependents, did not survive the deceased. What happens to the shares of those different categories, or the shares of the dependent, where you have where you base your question now? So,
please
is that
lower
okay?
your,
Can we go to the
camera.
next section?
Just position your camera correctly.
Is that okay?
Yes, that's right.
Thank you. So we go to the next section where the Act makes a provision for the distribution of the estate if the deceased is not survived by the beneficiaries in the primary category. Okay, that's the one question you have asked, Sister Mwaka. So where the intestate leaves, number one, no spouse, the spouse's share goes to the children in the same proportions relating to their age or need, educational needs, or both. Does that make sense, Sister Mwaka? So that's where the deceased is not survived by the spouse. In the next category, where there's no spouse or children, I think that's the question that you are asking. Where there is no spouse or children, sorry, you are asking about dependents. The share of the spouse and children goes to the parents in equal shares. That's where both parents have survived the deceased person. If only one parent has survived, the share of those two categories of beneficiaries goes to the deceased's parents. Where the number three, where there's no spouse, children, or parents, the share of these beneficiaries goes to dependents in equal shares. And again, here, remember we said, in my view, we should really not include the priority dependents, because including them in all these other scenarios would decrease tremendously the estate that is left under the 10% to the other beneficiaries, to the dependent beneficiaries. So the no spouse, no children or parents, the dependents inherit their respective estates. Where there's no spouse, children, parents, or dependents, the shares go to the near relatives. Now, in the African sense, I think near relative is very easy to define. We talk about extended families. So you just have to get the people who are familiar within the family to define who the near relatives in that family are. So that is no spouse, no children, or dependents. The shares go to the near relatives in equal shares. Where, and this is where your question, Sister Mwaka, comes, where there is no spouse, no children, parents, or dependents. No, that is not. Where there are no dependents, that was your question. Is that a lacuna in the provision? Sister Mwaka, let me see your question again. Oh, yeah. So, as I said, that has nothing to do with the age. So, where the parents of the deceased are late, then you have no spouse, no parents, or parents, the share goes to the dependents of the deceased. But the question I'm looking at now is, what if there are no dependents in the estate? I can almost see that estate will be distributed to the priority dependents. That is the spouse, the children, and the parent. Okay. The last scenario is where you have none of the primary dependents. That is, no spouse, no children, no parent, no dependents. The estate then becomes what is called bona vacantia, which means there are no heirs in the particular estate. And as I said, in the African context, this is really very unlikely because of the extended nature of our family. Okay. So I just want to conclude on the distribution of the estate. Remember, we started off with the intention of the act. The intention of the act, which was primarily to try and take care of the situations of spouses who were not entitled to inherit under customary law, as well as the what's going on now? Okay. So as well as the children of the deceased in matrilineal societies in particular, where the children were not entitled to inherit, but instead the children inherited, in the case of a deceased man, the children who inherited were the nieces and nephews of the deceased. So I think that if we look at the schemes that we have considered, it's quite clear that the act intended to provide for the inheritance of the nuclear family, which is known as surviving spouse and children on one hand, and those of the deceased extended family, the deceased's extended family on the other hand. But we can also see that the distribution of the entire estate is actually tilted in favor of the deceased spouse and children. In fact, if you consider the provisions that provide for the house of the deceased, the chattels of the deceased, and those that make provision where priority dependents have to take where the deceased person left no other dependents, it can be concluded that the entire estate of an average Zambian goes to his or her spouse and children. And so to this extent, the Act achieved its main objective, namely the amelioration of the poor position of spouses and children under customary law. So before I go on to the next topic, though, having concluded that the Act actually favors the dependent, the nuclear family, I think one has to consider what happens in practice. A lot of my research has to do or to look at how this Act and even the Wills Act is implemented in society. In the early years of the implementation of this Act, it was a huge problem to actually change the mindset of people who were used to inherit under customary law to allow the deceased, this nuclear family, to inherit, particularly in matrilineal societies like the Tonga, the Bemba, etc., etc. Other practices on the ground happened that deprived the nuclear family, in most cases, of the property that they were entitled to. And I think those of the participants perhaps who have had this experience of, particularly in the early years of the implementation of the Act, will attest to the fact that the estate was nevertheless grabbed from the deceased widow, in particular, the deceased widow and children. The same people who inherited under customary law continued to inherit. And if we do not watch out when we are involved in the administration of estates, watch out for these kinds of practices, today you will still find people who actually don't inherit according to the rules, that is, the spouses and children inherit completely according to the rules. They might be given a pittance of the share of the deceased when they should have gotten the lion's share of that estate. And some of the things that have been used to deprive this category of beneficiaries are threats of, for example, threats of witchcraft. The widow, and I came across many cases in my research where the deceased's relatives are waiting outside the bank, for example, where the widow is the administrator of the estate and is withdrawing the money from a bank or from whatever other source the property is. They are waiting outside. And, if she doesn't hand over that property, they simply say mukachimona, and that mukachimona was sufficient in many cases for the widow to just give up all her share of the estate and the share of the children to the deceased's relatives, who most of them might not even be entitled to inherit under the Act, and some who were entitled just increased their share of the holding of the estate or the sharing of the estate from the share of the widow and the deceased. The other practice, of course, that we are most likely all familiar with is just this grabbing of the property. As soon as the deceased person dies, the property, unless it's all locked up properly, the relatives of the deceased who are not entitled or may not be entitled or are entitled to share the property descend on the property and begin to share before the mourning is over. The widow is still mourning, and so by the time the estate is ready to be administered, it is being depleted. Of course, there are criminal or there are offenses created by the Act for that kind of behavior of some members of the family towards the beneficiaries under the Act. But the problem is that if the property has already been distributed, you can send the person to jail for 2 years. And if they are as poor as I am, they are not able to make up the property that they have already squandered, particularly property in the form of money or property that can easily be sold, the personal chattels of the deceased that can easily be sold. So I don't know if there are questions on this, but I think that as beneficiaries under the estate, for me, the point to take home on this issue relating to the practices of the deceased, the take home point is that be very vigilant. If you are the administrator of the estate, and the administrator, you can be a widow, you can be any interested person in the estate, but as an administrator of the estate and as beneficiaries to the estate, be very vigilant about the estate and ensuring that it's actually secure before it's distributed to all the beneficiaries. Okay. Is there any question on inheritance? Milimo Munyati. So what happens to the deceased? Yeah, this is the question that was asked earlier. There seems to be a gap, actually, unless I have missed it in the Act. There seems to be a gap, but my suggestion to an earlier question was that this estate, because of the importance of the priority dependence under the Act, this estate is almost likely to be distributed in terms of the to the priority dependence, that's the spouse, parents, and children. Sister, my co-presenter, my co-panelist on the platform, can you help answer that question if you have insight into it? Because I think it's an important question. If the dependent share is 10% and the estate is quite big, that redistribution would be very, very important. Sister Kasumpa Kabalata, are you on the platform? Okay, it seems it is not. So, Milimo, I think that that is the answer I can give. I haven't, as I said, I haven't come across a case which has actually dealt with this pointed issue that you have raised. But if I find the answer when I send the slides, I will include it in your slides. I hope that's okay, Milimo.
Yes, thank you.
Okay. Is there any question before we move on to the administration of the estate, where I just want to mention a few things. Perhaps let me say something else relating to our presentation last time we met. Remember, we talked about the concept of domicile. What is the importance of that concept? Now, in Zambia, that concept relates to what law should apply when a person is not domiciled in Zambia and when a person is domiciled in Zambia. Under the Intestinal Succession Act, both the real property, that is land, houses, are governed by this Intestinal Succession Act. The real property and the personal property. But the rule itself is that where there is a conflict between the law of Zambia and the place where the immovable property is situated, according to Zambian law, the immovable property is distributed according to the law of the place where that land is located. So if, for example, a Zambian dies in another country and they have property in that country, landed property or land houses, the Intestinal Succession Act will not apply to the distribution of that property. The law of the country where that property is located will apply. And so it's in those situations really where, the person who is not domiciled in Zambia or might not be domiciled in Zambia, the best way to protect, to ensure that, that property is distributed according to the will of the deceased is to make a will, as was presented by Sister Kabalata. I thought I should just mention that to show how, this landed property, according to the Zambian conflict of law rules, is distributed. Most of the estate, the real estate in most of the estates are distributed according to the Intestinal Succession Act, but that's because the deceased persons are domiciled in Zambia. they are domiciled in another country, Zambia has a law, a rule of intestinal succession, which says that property will be distributed according to the place where the deceased was domiciled at the time of death. The personal property, according to Zambian law, will nevertheless will always be distributed in Zambian law. That's our conflict of law rules. Does that make sense, to link the concept of domicile to the distribution of the estate? Okay, there's a comment. Let me see if it relates to that. Is the 30% shared between children and widow? Which 30% now? Sorry, which 30%? Who asked that question? Which 30% are we talking about? Because there's no 30% which is shared between the children and the widows. In the primary scheme of distribution, we have seen that the widow, the surviving spouse has 20%. The children have 50%. If you are talking about where the deceased has no parents, then we can't really say the 30%. We are simply saying whatever the share of those persons who died before the deceased person, if it's the deceased person was the parent, then that 20%, maybe that's what you are talking about. And the other deceased persons, or the deceased has no dependents, which is 10%, then the 30% is shared between the children, not just the widow, the children and the surviving spouse, the husband as well. Okay, the widower, if you like. So they will share that, the totality, the aggregate of that amount of property, according to their shares under the Primary Act. Okay, so what of vehicle used at home, is it supposed to be shared by the widow and children? That is a personal chattel easy, and we said that under the special exception rules, all chattels are shared by the widow and the children. There is no special definition when you say used at home, unless you are talking about a polygamous marriage relationship. But yes, that car or vehicle will be shared between the widow and the children in equal shares. Okay. Unless, of course, they say the child can show that the degree of dependence of that child on the deceased requires the court to readjust the shares of the widow in favor of the child or the children. Is that okay? Easy or easy? I'm not sure how you pronounce your name. Okay, I think those are the questions on the notes posted. So let's just say a few things on the administration of the estate. I mean, this is a whole huge topic on its own, which I really don't intend to cover in much detail. It's also quite a technical, more practical aspect of the Intestinal Succession Act. which I am not very conversant with in terms of the practical procedural realities of administering the estate itself. What we look at are, the provisions of the Act relating to administration of estate. So here we are looking at primarily at Section 15 of the Intestinal Succession Act when we are looking at administrators of the estate. And this provision states that any interested person or persons may apply to a court for administration of the estate. Now, there are 3 sets of courts that have jurisdiction to administer the estate, to issue letters of administration of the estate. And this is a very, very important point to remember. You have the local courts, you have the subordinate courts, you have the high court. All these 3 courts have what is called original jurisdiction to hear an application by a person who wants to be appointed as administrator of the estate to apply to any of these courts. What determines the court where the administrator goes to is the value of the estate. The value of the estate determines the jurisdiction of the 3 different courts where you can go. So I said it's very important because you don't want to take an estate of 50,000 kwacha, which falls within the jurisdiction of the local court, to the high court, where the costs for administration of the estate are very high. The other, so those estates go to the local court. The next value is the 100,000, unless these again have changed in the years that I haven't conducted updated research. 100,000 to magistrates' courts, and then above that, the estate goes to the high court. So to administer an estate, you need an order of the court, or what is called letters of administration, for you to start touching the estate of the deceased to administer it. If you do that, you will be meddling with the estate and2 be prosecuted in terms of Section 14 of the Act, which would send you to prison for 2 years. Maximum, of course. You can pay a fine of 700 units. And I think Sister Kabalata mentioned that each unit is about 3 kwacha. So you can multiply what you would be liable to pay if you breach, you commit a crime under the Act. So that's very important. Any person, and where we have talked about property grabbing, where we have talked about people who are not entitled to the estate wanting to meddle with the estate and, take advantage of the beneficiaries of the estate while they are mourning. The most I think useful approach is for the surviving spouse to administer the estate, particularly for widows. This is the safest I think I can suggest. But the law also says that where more than one person applies, the court may grant letters to one or more of them, taking into account the greater or immediate interest in the deceased's estate in priority to lesser or more remote interests. So in other words, a child, if there are more than one person applying for letters of administration, a child, say a child and a mother, because children have, if there's one child, they have a greater interest in that estate, the 50% share, and would therefore be allowed or preferred if they are not minors to administer the estate in comparison to the person with the lower interest, that is the mother, the parent, or the dependent. So that section is quite important. But in one of the cases, again, the Supreme Court held that or decided that from the Act, it's clear that being a beneficiary, including even a priority beneficiary, that is a spouse, a child, or a parent, does not per se give the beneficiary priority eligibility to be appointed as administrator of the estate. So, for example, if the child is a minor, as I have already said, obviously they wouldn't be appointed to administer the estate. Or if, for example, the parent of the deceased is probably more knowledgeable according to the factual situation and on the procedures and the law that are required to be complied with to administer the estate, than an adult child who is a single child, the court may appoint the parent to administer the estate. So it's not, you are not entitled automatically by the size of the share of your estate to administer the estate. But the Act restricts the number of administrators who may be appointed. Letters of administration, in any case, cannot be made to more than 4 people. And if there is a minor in that particular case, or a life interest, we said that the widow is not just the widow, a surviving spouse is entitled only to a life interest in the house. So if there is a life interest in the estate, or there is a minor, letters may be granted only to the Administrator General, who is a government official. So, or a trust corporation solely or jointly with an individual, or not less than 2 individuals. So those are the restrictions that apply to the administration, appointment of administrators to the estate. What if no person applies, or no person feels competent enough to administer the estate of the deceased? The Office of the Administrator General is available to every citizen in Zambia to their estate to administer it on their behalf. So the estate can be reported to the Administrator General for purposes of administration. There are difficulties there, frankly. I have done a lot of research in that office. Yeah, I think there's much that can be done to improve the operations of that office, where in some cases, the cases run for administration, the cases run up to 10 years, going to 15 years. In the meantime, some beneficiaries may die. So there is a bit of problem with the Administrator General. And I personally, at this stage, there is improvement in that office. It's probably better to find an administrator other than taking the estate there. So then we come to the powers of, are there any questions on who may be appointed as administrator? Sister Lufungulo, when should we stop?
We have
overshot.
minutes to go.
How many?
3, just 3 minutes.
Oh, sorry, I can see the number has dropped considerably. Okay, so anyway, just very briefly on the powers and duties of an administrator. The powers and duties of an administrator are to pay the debts, funeral expenses of the deceased, and any other estate duty that is due to the government, and any other payable liabilities on the estate before they can distribute the estate. And also to administer the estate, to distribute it in terms of the schemes that we have just concluded, or which we have considered. And if the court, for example, requires that that particular administrator provide an inventory as a way of controlling the administration of the estate, if the court considers that the administrator should render a full inventory, that administrator is required to do so to the court. But let me emphasize that the administrator is not a beneficiary of the estate unless they are also beneficiaries in terms of the schemes of distribution that we have considered. But as we saw, any interested person can apply for administration of the estate. And that interested person may, for example, be a person who has been appointed as guardian of a minor child, or a creditor to the estate. Any other person can do it, but please, and this has been a lot of abuse. This is where a lot of abuse has happened by the administrators, where they actually consider themselves to be beneficiaries while they are administering the estate. Begin to share the rentals from the house which is being rented in the interest of the beneficiaries. Again, that is intermeddling or meddling with the estate, and the administrator can be prosecuted. Okay, I will stop there, because the rest of the stuff on administration goes into details of, the effect of administration, the effect of the grant of letters of administration. I think the most important is who can be appointed. If we had time, of course, we would go into a few more aspects of the administration of the estate. But who can be appointed, and the functions of the administrator are quite important at this stage. Finally, let me just say a word about the guardianship of the children of a deceased person. The court, as the supreme parent of children in the country, can appoint any person other than the parents or the surviving parent of the deceased, surviving parent of the child, as a guardian to the child, and that guardian obviously would be charged with protecting the interests of the deceased minor children or minor child in the estate. So, Sister Fungulo, can I answer these two questions?
Thank you so much. Any questions from our audience? Do we have any pressing questions?
Okay. What is an administrator or deposit? This, I think, will also depend on the size of the estate. There's a provision in the Act which I can't see now, but the court may require the administrator not only to make a guarantee of good administration of the estate, particularly if they are not a member of the deceased, the beneficiaries of the deceased. Sorry, who is this now? Who asked Nkumbu? I can't see at the moment the actual fee, but I know that the court can assess depending on the size of the estate, because the deposit or the guarantee is actually intended to ensure that the administrator does not run away with the estate of the deceased or misappropriate the estate of the deceased. And if they do, the beneficiaries can have resort to that guarantee. So the court would have the discretion, depending on the size of the estate, to decide on the guarantee that should be deposited on the estate. Okay, I will stop there. Thank you, Sister Fungulo. Thank you, participants, for listening to me. I do appreciate your interaction. And again, my apologies for coming into the meeting late. Technology is not my future. It's my past. Okay. Over to you, Sister Fungulo.
Thank you so much. Indeed, technology can sometimes distract us. I hope the audience, you have picked one or two things. If there's any pressing questions that you want to know, please, you can inbox me so that I can share the contact with her so that you are free to ask. If we have any other pressing issues, we are so thankful that we have learned one or two things from this discussion. This is a series on wills and inheritance. So we shall let you know when we shall have the next one very soon. Sister
Lufungulo, I hope we have learned, Sister Lufungulo.
Yes.
I hope we have learned more than one or two things.
We hope so, very much, very much. We are receiving so much responses from people. They are really appreciating, but they are even asking for the topics or material so that they can have it themselves and read more and more time.
Or someone had asked where they could buy the Intestinal Succession Act. These are usually sold at the government printers. So I hope that they have got it. But the easiest is just go Intestinal Succession Act, and you will have it. It's there. The full copy of the act is there. And you even say, I think one of the provisions on the guarantor that is or someone else has asked. So it's there.
Okay, thank you so much. You have heard, viewers, that is there. You can go to government printers for any, if you want that copy.
No, go to Google. Google
Also.
Intestinal Succession Act and print. Then you don't have to buy. You might not even have it at the government printers.
Technology. Thank you so much.
Okay.
Technology. Thank you so much. So until then, we are grateful and thankful so much. We'll ask Sister. We have Sister Imonga. You give us the closing prayer.
Okay, let's pray. Gracious and loving Heavenly Father, we come before you. Thank you so much for giving us this opportunity this afternoon to interact on this very, very important topic. For most families, dear Lord, the only property or source of support when a major member of the family passes away is the estate that they leave behind. I pray that what we have shared this afternoon and what we will share in the form of materials will help our sisters and brothers who are interested in this subject. And dear God, I pray that you will bless each one of us for the rest of this coming, protect us from harms and dangers, from the diseases that are ravaging this country and other countries in the world. Lord God, help us that all of us who are in this platform can take, as Sister Fungulo said, one or two things to assist them in the event that a situation that requires to apply this act arises in their individual lives. Bless them, I pray, in Jesus' name. Amen.
As usual, at Central Church, we have a custom of opening our videos so that we can wave to our presenter for the day. Thank you so much. You can mute and say something and wave to the presenter.